Hello, everybody, and a very big welcome to you all to the Alliance of Business Lawyers webinar, How to Start an E-Commerce Business, a Step-by-Step Guide. Now, due to COVID-19, and I do apologize that it gets its first mention within seconds of starting, but because of COVID-19 and the ever-increasing lockdowns and business interruption, it is shown how crucial it is for businesses to have a route to market, selling their goods and services online through e-commerce. Now, we obviously have positive news on the horizon, vaccines and so on, and of course we hope for a return to something like normality in 2021. But e-commerce has shown itself as not just the here to stay as a mainstay of business, but indeed the key market for many traditionally offline businesses, or what we call in UK bricks and mortar businesses. Now, as you can imagine, this is a huge topic, and we welcome you today to hear three speakers on three specific aspects of it. Firstly, my name is Neil Pfister. I'm a commercial partner at Druce's LLP in London. And I'll be giving an overview on choosing the right jurisdiction and corporate structure for your e-commerce business. We also have Blaise, who is attorney at DGM Advocates in Geneva, and he'll be talking to us about drafting terms and conditions and some VAT aspects for your new e-commerce business. We are also expecting on a call Steve Lincoln, an attorney at Brown, G and Wenger LLP in San Francisco, to be covering issues such as copyright and privacy, but protecting your brand and your content online. Now, as you can see, we're speakers from all over the world, and in particular, once he joins, because we are still waiting for Steve at the moment, a couple of technical issues. Thanks to Steve for making the call so early in the day over in San Francisco for him. But we are, of course, all members of the Alliance of Business Lawyers who have kindly today put together this series of webinars. And I mean, the ABL is an association of business lawyers from all over the world. So if you do have any questions specific to any of our jurisdictions, please do contact Sophie at the ABL, who will be pleased to put you in touch with the appropriate member. If I may, just a quick bit of housekeeping for the webinar. You'll see either at the bottom or the top, depending on your device, of your Zoom screen, an option to ask questions through the Q&A button. If you have any questions for any of the speakers, please type these in, but please do put in at the beginning of the question who that question is for, and we'll try to answer as many of these as possible after the three talks. If we can't answer them all, we'll try to come back to you offline after the webinar as well. So, kicking straight off and choosing jurisdiction and corporate structure. And now, this is something that we commercial lawyers get asked a lot. You know, where is the best place to start and base your new e-commerce business? Now, sometimes this might not be an issue for you. You know, if you're setting up an e-commerce wing of your existing business, essentially this will be part of that existing business, and totally new startups though will have more flexibility and a bit more choice about where they may want to base this. So the sort of considerations that are often put to us are tax efficiency, you know, route to market, the ease, the convenience of managing the business, and things like access to products or access to staff, and ease and convenience of managing your employees as well. So starting, if we can, with tax efficiency. Now, clearly this is a very important consideration, but and in fact it's the sort of question we're asked more than any other, I would suggest. But my strong view here is it should never be the sole reason to base your new e-commerce business in a particular jurisdiction. The contracts that your business, your e-commerce business, will enter into will be with the entity that you use for that business, and basing it in the BVI, the Cayman Islands, or other tax-efficient jurisdictions will lead to plenty of practical difficulties for you, including, you know, setting up bank accounts, contracting with customers, many of whom may not appreciate you using an offshore jurisdiction, or indeed contracting with suppliers, and certainly many more of these will not appreciate an offshore jurisdiction. Now, I mentioned their bank accounts, and this is a bit of an interesting topic in its own, actually. So your new e-commerce business will, of course, need a bank account in order to send and receive payments. And the actual setting up of a bank account is not an easy thing in today's climate. By way of example, in the UK, nearly all major clearing banks have stopped opening bank accounts at the moment for new customers as a result of the pressures from COVID and dealing with various grants, loans, business support funds, bounce back grants, and many new e-commerce businesses we're seeing are having to resort to some of the new online challenger banks, banks such as Tide or Starling Business or Monzo, you may have heard of. So you really should think very carefully about the difficulties of physically opening a bank account, a business bank account, particularly considering the difficulties that you might experience in getting a bank account open when you're not resident in that country or jurisdiction as well. Because whilst the online challenger banks are a very welcome new part of the banking market in the UK, it's very much ticking a box on the screen, and if you don't meet their very rigid preset criteria, you are going to find difficulties. So, for example, an overseas director might automatically say that they can't open the account for you. So, a very important part that where to choose the jurisdiction. So, moving on to what I think is the key one here is your market. Now, where your market for your business market is going to be, it should really be your absolute key consideration. There are considerable advantages to basing the business in the market where you are looking to sell into. So ease and convenience of contracting, both with customers and suppliers, but also taking on board employees. This will make your life much, much easier if it's within the market that you're looking to sell into. It's also worth considering the platform you're considering using for your e-commerce venture. We have platforms such as Shopify, eBay, Etsy, many others, and they have specific requirements for the type of business and, more importantly, the location of the business that use their platform to sell into certain country or national markets. So you are very well advised to read these in detail, as they could be the main determining factor into choosing the correct jurisdiction for your new business. Now, choosing the right market and the right jurisdiction has a number of important commercial, so not really legal, but a number of commercial implications as well. Clearly, Amazon has become the titan of e-commerce it is today. Incidentally, making Jeff Bezos, the founder, the world's richest man, and even his ex-wife, Mackenzie Scott, is today the world's richest woman simply because of the divorce settlement she got from Jeff. But despite Amazon's success, there is an increasing focus, and we're really seeing an increasing focus on shopping local, and the environmental and the community impact of international e-commerce as opposed to buying from local suppliers. So basing your business in your local or perhaps your national market is becoming much more of a must for new e-commerce ventures looking to enter that market. And depending on what it is that you're looking to sell should really be a very important, if not a key consideration for you. And of course, there are other commercial implications, such as the cost and convenience of shipping and things that will stem from being based in your local market. Another factor is the ease of incorporation or starting the business, and the ease and convenience of managing that business. And I'd suggest this should be a key factor for you as well. It is just a fact that some countries are easier to incorporate or start a business than others. Not only are the legal formalities different, but the costs of starting and running a business differ widely from country to country too. So, for example, to incorporate and start a limited company in the UK costs the princely sum of £11. The average cost in the EU is €300, but rises to €2,000 in Italy, or 20,000 Swedish krona in Sweden, which is approximately £1,900. So if you are considering establishing and running a business that trades overseas, perhaps in a number of multiple jurisdictions, it may be worth incorporating the business, starting the business in a low-cost, easily administered jurisdiction such as the UK, but others are available, and using the much cheaper option of then registering branch offices in those other jurisdictions, so branches of the main business where you're looking to trade or sell your goods and services. Often the cost associated with a registered branch is it could be as low as 1/10 of the cost of actually incorporating a new business within that jurisdiction. So access to overseas markets is the next point I'd like to mention, and this is a very live issue in the UK at the moment. We try not to say the Brexit word too often, but it is unfortunately a live thing. Sadly, it's an area where I can't give you all the answers right now because they're still negotiating. But if you are looking to incorporate in the UK and sell throughout Europe, you would be advised to wait, hopefully not for too many more days, to find out what sort of a deal, if indeed we do get a deal, and what sort of tariff arrangements may be in place for your goods and services being sold from the UK to international markets. Now, of course, this is not to say that the UK is or will be an unattractive place to start or to base your business, but access to overseas markets and the implications of additional tariffs and checks on trade, such as data protection, flow of data, homogenization of standards for goods. These are key questions that should be very carefully considered when you're choosing jurisdiction. So moving on from jurisdiction and just touching on what sort of business structure you may want to consider. And these, of course, differ from country to country, but as an English lawyer, I will touch here on what we have in the UK, which are, we start with sole traders, which is essentially you as an individual selling and trading as yourself. We have limited companies, which are so companies limited by shares, which is by far the most common. And means the company is effectively a legal entity in its own right and is able to contract on its own behalf, acting by the directors who run it. Now, key with this is the limited means that liability is limited to the value and assets of the company rather than the personal liability of the business owners or directors. Next, we have partnerships. Essentially, here a partnership is a collection of a collective, if you like, of sole traders who are working together for a common business aim. And then we have limited liability partnerships, which is a form of cross really between a partnership and a limited company. Though to be honest, they are less commonly used for e-commerce ventures. Now, there are, of course, more formalities and more administration and costs in using a corporate structure, such as a limited company, as opposed to a sole trader. But the benefits of having a legal structure which can contract, or a legal entity which can contract on its own with suppliers, with sales platforms, with banks, with employees and customers, it makes this by a considerable distance the most popular structure for most new e-commerce. Plus, of course, as I mentioned, you have this added benefit of limited legal liability for the company's debts and contractual liabilities, not just liabilities with suppliers and customers, but also liabilities with employees as well. Now, whatever corporate structure you do decide on, I urge, and I'm sure my co-speakers also urge you strongly to speak with an attorney before setting it up. It is, of course, possible always to change aspects of corporate structure, such as shareholding, subsidiary companies, dates, and so on, after a business has gone live. But it is better for a lot of reasons to have this correct, such as engaging with banks or securing funding and investment for future funding. It's so much better to have that correct before you actually launch it. Now, I mentioned obviously contracting with customers, which I think gives us a very neat segue for me to pass the mic to our next speaker, Blaise, who will give an overview of terms, conditions, and contracting with customers.
Yes, thank you very much, Neil. Yes, so I'm going to talk about this other topic of terms and condition. We also have a lot of customers that ask us some questions about it. So I'm talking about terms and condition and not about privacy and IP issues so far, but talking about terms and conditions means talking about consumers' right mostly. Consumers' rights concerns the relationship between the business and the consumer, a consumer being understood as a natural person who is acting not within the frame of his commercial or professional activity. Consumer right may concern the selling of goods as well as the providing of services like online teaching or delivery services that you can contract on the internet. So I will talk about mainly the EU legislation, and the consumer right is mainly ruled by EU directives. We have a lot of them. I will not name them all, of course. I will not be able to come into each of the details, but I will try to make a global a view of all the different issues. I mean, the main issues that may come into consideration when drafting terms and conditions when designing your website. So the main directive is the directive on the consumer rights, and then you have the directive on electronic commerce, many other directives, and some directives for specific sectors like passengers' right, package traveling, financial services, or gambling activities, for example. So being ruled by directives, these are only harmonization rules, as you know. So this legislation needs to be transposed in the national law, and the national rules may vary from a country to another. So this is why you need to go um, to see the legislation in each country where you want to develop your business to know what is the exact consumers legislation and consumers rights. The consumer legislation is mainly about information duty for distant contracts. So you need to inform your customers, and you're going to do it mainly through your terms and conditions, or maybe you will mention this information at another place of your website. You have to know that there are sanctions if you don't follow these rules, especially with the New Deal for Consumers, which is a revision of the EU consumer law, which will come in force by 28 May 2022 at the latest. We have with this new EU law, consumer law revision, penalties which may rise up to 4% of the annual turnover in the concerned member state or member states, or up to 2 million euros in certain cases. Furthermore, you have different national competent authorities, and you have mutual assistance between the national authorities for the consumer rights protection. These authorities may investigate, and they may take some measures like until closing your website. So you have, of course, to pay attention to this legislation when doing e-commerce. In Switzerland, as I'm working in Switzerland, you know, we are not a member of the European Union, but we have, however, have a lot of bilateral agreement with the EU. And talking about the UK, we have already concluded some trade agreements, among others, to keep our relationships. Talking now about consumer protection in Switzerland, we are widely influenced by the EU legislation, but we still follow our own rules. We are on the one hand a bit delayed, but we also have a more liberal regime in Switzerland. As for example, we don't have the withdrawal right for online commerce, which we have in the EU law. So now, when it comes to drafting your terms and conditions, as soon as our clients wish to make business, cross-border business at least, so they don't want to make business in one single country like Switzerland, but they want to develop their business in different countries, we mainly advise that they follow the EU directive as a basis, and then to adapt your terms and conditions, because you will probably need to adapt them for each country where you are going to be active and sell your products or services. So the drafting of the term of conditions depends on the location of your customer on one end, as I said, but also on the type of online business. So when you are running a website only for advertising purposes, you have, first of all, IP issues. Of course, if you are using picture, you needed to check that you have the consent of the IP owners before you using this picture on the web, of course. Um, then you have also some duties according to the e-commerce directive, like clearly saying what is your identity and your address, and clearly and making it clear that it is a commercial presentation, communication. Now, we also have rules about the price indication, as you know probably. So the price, if you are indicating price, must be indicated the selling price as well as the unit price, and also all the taxes should be included, including VAT. This mainly applies to the sale of goods, but in some member states, it might apply as well for services. Furthermore, with this new deal for consumers, which will come into force in 2022 at the latest, if you announce a price reduction, you will have the obligation to show the lowest price that you applied, at least during the last 30 days. So this will be a new provision in the EU consumer law, coming into force in 2022 at the latest. Furthermore, still with advertising, there are different rules also for specific sectors. For example, we have advertising of medicinal products for human use directive, which will concern this kind of products more especially. We also have a directive concerning misleading and comparative advertising, which you might have a look to before you're advertising on the web. Secondly, if you want to sell goods or provide services online, so if you want to contract, to make the contract online and not just advertise, we have a lot of pre-contractual information requirements which should be an integral part of the contract, which means that the client must explicitly accept the terms and conditions. So this is why when you are buying something on the net, you always see that you should tick the box to confirm that you accept these terms and conditions, although you did not read it. This is more opt-in, so you really have to tick the box because before you can confirm your order. There is also this rule that there should be this order confirmation button on your website, so that the client really know that he is buying when he's touching this last button, and that is concluding a contract doing this. So the information requirements that need to be mentioned on the website when selling a product or in the terms and conditions are, of course, the main characteristics of the product, of what you buy, the identity of the seller and his address, the indication of the price, inclusive VAT, I told it. Then you have the arrangements about the payments, about the delivery, about the performance of the contract. You have the withdrawal right. You have to mention the legal guarantee for conformity of the goods, the duration of the contract, automatic renewals, or the termination of the contract as well. And finally, you have, depending on the member states, of course, some language requirements. Now, these rules does not apply exactly the same, or it might differ for some other fields, like I told, like health, like gaming, financial services, real estate, and tourism, notably, or food and beverages. Going now to the withdrawal right. So in EU, you have a 14 days withdrawal right, which applies both for services and for goods. The delay of 14 days starts with the conclusion of the contract for services. but with the delivery of the goods in case of selling of goods. What is important to know, if you omit to inform the consumer about his withdrawal right, the withdrawal right might last for a period of 12 months, because the consumer may come back after the 14 days period until the end of this period of 12 months. Um, Also, it is to know that you are not refrained from executing the contract during the withdrawal period. And of course, if you provide a service before the end of the withdrawal period, um, the withdrawal right will not be valid anymore if it was executed with the agreement of the customer, of course. We now have some exceptions, for example, for personalized products, for some sealed goods or sealed multimedia products, if they were unsealed, for example. Now we also have provisions about the delivery delay. So if nothing is written in your terms and conditions, in principle, if you are selling goods, you have a 30 days delay to deliver it to your client. If you cannot make it in 30 days, you are better to indicate it to your client before he confirms his order. On the other hand, as for example, we don't have such a delay by the law in Switzerland. Um, then, of course, we need to put in your terms and conditions the applicable law and the place of jurisdiction, but of course, some mandatory rules may apply, which will make this provision, which could make this provision not valid. Finally, you might have heard about the unfair or abusive terms and conditions. We have some directive in the EU, also the Unfair Commercial Practices Directive, for example. What does it mean? Of course, it's not very simple to know what is abusive term or condition. It is defined as causing a significant imbalance between the parties' rights in the detriment of the consumer. As for example, you have if you exclude or limit the consumer rights in the event of non-performance, if you have disproportionate compensations or excessive extensions of the contract duration, impossibility to terminate the contract, and so on and so forth. So this is what I wanted to say about these terms and conditions, and maybe we have some time because I see that Steve did not appear so far. Maybe I can give a few words, say a few words about the VAT. If we have sufficient time, because we said that the price needed to be indicated clearly, including the VAT. So this might trigger some difficulties. As you know, the rate of VAT may vary from countries to countries. We have 7.7% in Switzerland, which is very low, and we have EU countries with between 17% in Luxembourg up to 27% in Hungary, for example. So the principle with the VAT at the present time, which is coming more and more, the aim of the VAT is that it is taxed at the place where the consumer is situated. So following this principle, you would in principle need to register in various member states to collect the VAT at the various rates of each state, which is obviously quite complicated. We had some exceptions with distance selling with maximum of 100 euros, 100,000 euros or 35,000 euros, depending on the member states. In this situation, you could pay and register for the VAT only in your own country, in the country of your business. We then add a VAT for digital services, what was called the mini one-stop shop schemes. So it was made for website hosting, supply of software, access to databases, or downloading applications, online gaming, and distance teaching. With this kind of business, you could go through a single registration with one country for all your customers in all your EU countries, and then you had to fill you had a single relationship with one office for VAT, but which would apply the different rates for the different countries. So now the good news is that we have this EU e-commerce VAT package, which will come into force 1st of July 21, which will concern business to customer distance supply, both of services and goods, and which will be called the one-stop shop. So you will also be able to register and pay the VAT only in the place of your business, even though you are selling in other EU countries. Of course, I'm not talking about Switzerland, but because Switzerland, you will still need to be registered in Switzerland if you are selling to customers in Switzerland and if you fill the conditions. But if you are selling inside the EU, you will be able to use this possibility. So, and there is another possibility to make your customs declarants, postal operators, courier firms liable to collect and the import VAT from consumers. So you can delegate this service at certain conditions to your postal carrier service, for example. So we are looking forward for this simplification process, but as I told, which will not be valid in Switzerland. So that was it about the VAT.
Thank you very much indeed, Blaise. Now, and as Blaise said, unfortunately, it looks like
I think we cannot hear us.
Yes.
Hi.
Thank you.
So, hopefully you can hear me now. Yes. So, as Blaise said, apologies that unfortunately technical difficulties have shown that Steve is not able to join. But the part of his discussion was going to be about intellectual property and protecting your content. Now, I wonder, it's an area that I do cover as well, so I'm very happy just to share some initial thoughts myself. It won't be anything like as good as what Steve had got prepared, but I will share a bit if I may. And firstly, when you are looking to incorporate, what you need to really consider the name that you are choosing in your particular market, because of course you go to the extent of registering a company name, choosing a trading name, designing a logo, considering trademarking, choosing a website address and domain and so forth. And these are time-consuming and costly exercises. And they are particularly time-consuming and costly if you get them wrong and realize that either you are subject to, say, a trademark infringement action, or worse still, a form of passing off action. And it is one of those areas, just like asking for attorney on choosing the correct jurisdiction and corporate structure, it is one of those areas where you need to spend a little bit at the beginning to avoid the big expense later on. Because with e-commerce businesses, we generally aren't talking about big premises, bricks and mortar businesses. Your value in your business is your name, and choosing the correct name and actually engaging with perhaps a branding agency or indeed an intellectual property lawyer once you have chosen your jurisdictions and your market, to ensure that you are open to registration, that you are not going to hit any snags if you apply for a trademark. That is money very well spent at the outset to ensure that you're not going to have to pay the price for it further down the line. And of course, essentially with an e-commerce business, the moment you have to change aspects of your branding, you put your business right back to the very beginning, because you have lost all of that goodwill you may have managed to generate, or unfortunately have piggybacked on someone else's up to that point. So we can't stress enough how important it is. And the other good news there is it is not particularly expensive or time consuming to do that exercise as well. Particularly I talk in the UK, and Blaise, I presume it's very similar in Switzerland as well.
Yes, of course it is the case. So we also advise our clients to make a deep examination when choosing their business names and when designing their trademarks. And also we have to recall that you have different kind of trademarks. You have wordmark, logos, you have three dimensions, marks and sound mark and so on. So you can develop your trademark and make it registered. Yes, and you can register designs if you are making some kind of particular goods. Yes, so this is something very important and quite complicated because it needs a lot of research and checkings, especially if you want to make your business on the web. So you may compete with a lot of people at the end, and a lot of names are being used by someone else quite easily.
Indeed.
And it might be complicated, especially about the domain names also. So we have some litigation about the domain names, which can be difficult to solve sometimes. Exactly.
They can indeed, and it's something we see a lot, the domain name disputes. And since we have a bit of time on this, it's worth mentioning a wonderful old case for a domain name dispute. And back in the day, now we have actually a very good set of rules and process for people disputing a domain name. If you have a legitimate purpose to use a domain name, you can use ICANN's domain name dispute process. But before this was put in place, you had to demonstrate that you had a legitimate reason to use a domain name, and people were buying domain names to simply squat on them. Cyber squatting, it was called. And we had a case in the UK for the British Airports Authority, who had registered BAA.com. And it had gone all the way to the steps of the court. And the case that the defendant, the guy who was holding this domain to ransom from the British Airports Authority, claimed that he had he set up a website for the Sheep Appreciation Society, or bar.com. So that's actually the extent that people would go to sort of protect domain names back then. Thankfully now it's much more straightforward. We have the ICANN process, and it's very similar again with trademarks as well. We have a trademark process where if someone is not using a trademark and hasn't used it for a period of 5 years or more in the UK, you can apply to have it revoked. And it's a very similar, through WIPO, it's a very similar process throughout other jurisdictions around the world as well. So again, it's exactly the sort of area to come and speak to an attorney if you are choosing a name and a brand that you feel someone else may already have. If we may, I think just before we turn to questions, please do submit any questions on the Q&A button if you have them. Before we turn to questions, Steve was also going to just mention briefly about data protection and privacy as well. Now, this is an area in the UK that is open to some interpretation, some immediate interpretation, because we are currently part of GDPR regime. Through that, we have, of course, quite an element of sort of if you like, equality of the way data protection is run throughout the European Economic Area. We include in that Norway and Liechtenstein. What is uncertain at the moment is whether the UK will still be part of the approved third country status after Brexit, after the transition period on the 31st of December 2020, which may mean that there are additional rules, additional contractual clauses that are needed for any commercial agreement, including buying and selling or engaging with suppliers, engaging with customers. So additional contractual clauses may be needed after on the 1st of January 2021 onwards. So if you are considering the UK or considering doing business in the UK through your e-commerce venture, that is something that we strongly recommend, again, that you speak to an attorney about, because these data protection laws are a big growth area. They're a big focus for both for the US, for Europe, and for the Intellectual Property Office. For the Information Commissioner's Office in the UK. So, so do expect some changes on that in the coming few weeks as well, particularly in reference to the UK. Blaise, if you have any comments on data protection and privacy for.
Yes, a few about the GDPR, maybe just to point out the main issues, like you need the reliability of your data, so your data must, among others, be updated. minimization of data principle also. So you have to limit the data you are treating to the maximum. And another point is the security of the data, which might trigger some cost, of course, and you might change your process, internal process about this question. The other point is the explicit consent of the person whose data you are treating. As for example, with the emailing, we have this e-privacy directive. So you may contact your clients by email if you intend to sell. If they have bought a product to you and you want to sell similar products, so this is the this is an opt-out option, but you cannot make any advertisement to clients without their consent. So it is an opt-in if you did not sell such a product to this client before. So this is another implication of the privacy directive. And the most important is also that the client must be informed about his data being treated. So this is also why we see all these notices about the cookies, that if you enter a website, then you have to accept that it uses cookies, which may contain some personal data like your IP address or so on. So I think maybe that these are the main points to say also about this regulation. And then you have a lot of rights, as you may have heard of, the right of access for your customers. So if you have a customer asking you what kind of data you are treating about him or her, then you have to provide this information, and sometimes with a certain delay. Yes, right to erase, right to have your data erased if it's unuseful, and so on.
Indeed. I mean, it's fair to say that protection, particularly here where we're talking about consumer contracts, which I think is the key sort of business area we're talking about for e-commerce here. Data protection is a subject on its own, and it's clearly not one that we're going to squeeze into the time we have left today. But again, if anyone has any specific questions about data protection for any of the jurisdictions that are covered by the ABL, please do get in touch with us through the ABL, and we'll be very happy to answer questions that you have. So talking of questions, we've got a few questions through. And the first one we have from Brahmanas, which is just a question saying, are we recording it to be shared? I believe that it is being recorded by Sophie at the ABL. So I'm sure she'll be able to get that and share a recording if you're unable to get everything through your technical issues there. The next question we have is from, and it's a very interesting question, it's from Nadia. Are there barriers to foreigners setting up that should be considered when determining a jurisdiction, such as minimum caps and expenses, etc.? I can answer here. In the UK, there are less barriers to people from other jurisdictions coming in and setting up businesses in the UK. We're a very open corporate environment for that. But certainly jurisdictions around the world do have quite strong barriers to entry. It could be that you need to partner with someone who is resident or a national within the country. It could be that the business has to be a certain percentage owned by the country. So it is very much differs from jurisdiction to jurisdiction. And it's a very point to raise, and something that really should be a big consideration when you're looking at choosing the relevant jurisdiction for e-commerce business. Blaise, do you have any thoughts on it from your point of view?
Yes, at least in Switzerland, if you start a corporation, depends what kind of activities you will do, of course, but one of the conditions is that you need at least one person responsible with signature right, single signature right, being in the trade register and with an address in Switzerland. So you need a Swiss resident in the board with a single signature right, for example. This is one of the conditions to open a company in Switzerland, a corporation for a foreign person.
Yeah, and that is mirrored throughout Europe as well, certainly throughout the European Union, in a lot of jurisdictions. Even actually where you're looking at registering a branch office, you may find that the branch, so you're not actually a new incorporation, but a registered branch office to trade within other European jurisdictions. You may find that the managing director or deputy managing director of that branch office needs to be either a national or registered within that jurisdiction to be the authorized signatory. So, and of course, needs a place of business within the territory as well. So these are very much barriers within Europe, but certainly elsewhere in the world, it's fair to say there are more considerable barriers based on ownership, quotas and so forth as well.
Yes.
So we've had a couple more questions. So the next question from Nanopa Vanda is, what are the legal implications of choosing a business partner in the EU or UK, especially Brexit? Now, I'm going to play the Brexit card here, which is that we don't know yet for the UK, because we are still remarkably negotiating a deal post the transition period for the 31st of December 2020. So it is unlikely that there are going to be big differences in terms of, as we were saying before, the requirements for incorporating and starting a business in certain jurisdictions. But certainly there are going to be implications in terms of trade from the UK to elsewhere in Europe. Blaise, do you have a view on that yourself?
Well, no, I think I let you answer this question about the EU or UK. I think it's more about your your domain or your experience.
Okay. So the next question we have from Anthony is, how about one starting or setting up a business, local foodstuffs in Nigeria? Quite a tricky one, that, because I'm not entirely sure whether you mean, are you looking to set up a business in Nigeria, or looking to set up a business importing foodstuffs from Nigeria to other jurisdictions? If it is in relation to actually setting up a business in Nigeria, it's probably not myself or Blaise you'll need to talk to about that. But if you are looking at importing foodstuffs from Nigeria, the choice of jurisdiction is important. And again, I go back to what we mentioned at the beginning about your choice of market. Where is it you're looking to sell products into? If it is the UK, then there is actually quite a well-trodden path of import from Nigeria, even of foodstuffs and so forth. There are a lot of regulatory hurdles to go through, but it is not, you're not reinventing the wheel here. It is done before, and we have food standards and import agencies who are very helpful about, in fact, about helping companies to establish. Just the okay. Well, I don't know if we have any more questions from that. I'm just having a quick look more on the chat. No, I think we have Steve now. Steve, so apologies, Steve. We have gone through and done the majority of the presentation, but we still have some time, about 10 minutes left or so. So if you're ready to give your spiel on your part, that would be very welcome.
I do. I'm sorry. It was my was this starting at 8 or 9 my time? I have it as 9 on my calendar.
I think it might have been. The joys of working throughout the world clearly is that's the issue, but there's no problem there. So you've come at the right time. So Steve, if we can pass over to you, we have about 10 minutes or so left. So. Sure.
Let me just share my screen and we'll go through it. Sorry, it came through the automatic calendar from ABL and it showed up as 9 a.m. on my calendar. All right, let me share my screen here and we'll start in on that. All right. All right. Can everybody see the screen that I've got up right now? Okay. All right. Can you all see my screen? I'm not hearing anybody.
Yes, we can see it. It's
Ah,
fine.
very good. All right. So I'm missing out on a little bit of what you've covered so far, but starting an e-commerce business from the U.S. perspective, the first thing, of course, is to set up the corporation itself. I don't know if you've covered this for the other jurisdictions or not, but in California, the first thing to do on the formation of a corporation is to do a name search with the California Secretary of State's office. I'm going to be discussing this from a California perspective, but most of the states are very similar to this. The first step would be to do a name search with the California Secretary of State's office to make sure that the name hasn't been used by anybody else. And the name of the corporation can be as similar as you may like to other corporations, as long as it's not identical for purposes of securing the name of the state. Now, the next step after that is to prepare and file the articles of incorporation. As you do that, you can list yourself as an attorney as the incorporator, or you can have one of the directors, the proposed directors, as the incorporator. But typically, the attorney will list herself as the incorporator, and then as the corporation unfolds, the directors will be named and the officers. The only other important thing to include in the articles of incorporation initially is the number of authorized shares. And there are forms on the California Secretary of State's office website to do this, fairly simple form. The next step after that is to draft the bylaws for the corporation. The important steps in that are to identify the number of directors. There are requirements under state law that it has to be on how many directors you can have. Typically, you have to have at least one director or 3 directors, and then you can have any number beyond that. The bylaws will also include, as you'd expect, the corporate governance rules on how decisions are made and so forth. And then you'll set out the officer roster on that, the roles of the different officers within the corporation and what they're authorized to do. As an attorney, the next step beyond that is to perform and to run the initial meetings of the board of directors and meeting of shareholders. Those can be done pro forma. They don't need to be done as an actual meeting. So everybody can just agree to the minutes of the meetings on those respects, rather than holding the actual meetings themselves. And then within the first 90 days, you also need to file the initial statement of information. And that's the first document that will go into the public record that identifies the names of the officers and directors and the actual address of the corporation. And so that's an annual obligation for for-profit corporations. For nonprofits, it's every other year. And then the final 2 steps for forming the corporation in California are to actually issue the shares, the initial shares of the corporation. And those are done by issuing the stock share certificates and recording them in the stock register. And then for closely held corporations, where you want to have the tax treatment, treat the corporation much like a partnership, where the profits and loss pass through to the shareholders directly without being taxed at the corporate level, you file a document with the Franchise Tax Board, and I believe it's Form 2552, and that you do that within the first few months, and that sets up the tax structure for the corporation. Now, moving on a little bit to the limited liability companies, the other main corporate entity that you might use for an e-commerce business, particularly if it's a small operation or family-run operation, is to set up a limited liability company. For those of you who may not be familiar with it, limited liability companies are sort of a hybrid between a partnership and a corporation, and they allow the same sort of protection that a corporation enjoys, but have more flexibility, much more like a partnership structure. And they're composed of members, much like members of a partnership, and a manager who can be a member or can be somebody who's contracted to be the manager for the entity. As with the corporation, you go through a name search initially to make sure that the name is not held by anybody else. And then you prepare and file the articles of organization. They're much like articles of incorporation, but a bit simpler. Sets out the name of the limited liability company and so forth. The governing document for an LLC is the operating agreement, and that sets out a number of things that are important to the governing structure. It tells who the manager will be, and again, it can be either a member or an outside manager, or it can be more than one person or entity. It will set out the ownership interests, how those are divided up, what the initial capital contributions are to the entity. It will include rules for entry and exit of members, how new members are added, how members can exit. And it will determine how profits and losses and capital accounts are allocated among the members. It can include more rules than that. It will also importantly determine how decisions of the entity are made. For routine decisions, it's usually the process is to allow the manager to make day-to-day decisions for the entity. And then larger decisions, things like whether to dissolve the entity, whether to spend above a certain level, whether to acquire another entity, whether to enter into major contracts, things like that are usually designated as decisions that need to be determined by a vote of the members, either by majority or sometimes supermajority, so that the interests of the members are taken into consideration for those large decisions. Once the entity's set up for an e-commerce business, obviously you need to have a website. The first step in that, as many of you know, is to register or purchase a domain name. And then following that, to arrange for website hosting with the company. And that is usually done by contract, often a standard contract that the host will have. And then to supply the content, you'll need to do website design, which can be done in-house, can be an off-the-shelf website package these days, website design package, or you may contract with an outside company to do the website development and design. And for larger projects, that's often the pathway. A website, in terms of content, should always include a set of terms and conditions that will set the rules for any user of the website, what terms they need to agree to be able to use your website. And often there'll be a provision in there that will say that by using the website, you agree to those terms and conditions. It's usually a better idea for sites where there's a commercial transaction going on to have some sort of an affirmative agreement to use the website, button to click or so forth. And in terms of websites should also include somewhere on the site a privacy policy that explains what use the owners and operators of the website will make of the personal information that may be captured by the user's use of the website or information that they submit. And then finally, to make the website most successful, it's usually a good idea to have someone in-house or an outside company perform search engine optimization, so that the website appears, so that terms within the website appear in search engines sufficiently frequently enough to generate traffic to the website of the type that you wish. One other consideration for e-commerce business, I don't know if this has been covered by the other folks at all, is copyright of the website content. And just to give a quick overview for those of you maybe a little rusty on copyright law, the content of the website, anything that you've created and put on the website um, in the US becomes subject to your, you gain copyright rights in it at the moment of creation, the moment it's created in a tangible form. And you enjoy copyright rights from that point forward, but your rights can be enhanced by registering the copyright in the content with the US Copyright Office, and that's done by submitting a copyright registration form and copies or samples of the work along with it. It is important, not necessary, but it is important to place a copyright notice on all copies of the work on the website pages. And the reason is that gives notice to the world that you're claiming a copyright in the content, which then is important for determining later on whether any copyright infringement that someone else might commit is willful or not. If there's a notice of copyright on the website, it's harder for someone to claim that they didn't know that it was copyrighted, or their infringement would be deemed to be willful. The other main advantage of having copyright registration and the copyright notice is that under US law, in order to receive damages in a copyright infringement lawsuit, you'll ordinarily need to prove actual damages and loss of profit in the course of your lawsuit. But if you have a copyright registration for the content that's being claimed to be infringed, you can obtain statutory damages, and statutory damages in the US run up to $150,000 per violation. So that actually provides a lot of leverage if you get into a dispute or litigation over a copyright violation, to be able to achieve a speedier settlement with the infringer. And I've had that experience in a number of cases where, because our client had obtained copyright registration for their work, we were able to get a very satisfactory settlement fairly quickly. So that's sort of a quick run through of US considerations for e-commerce business.
Lovely. Well, thank you very much indeed, Steve. And apologies for putting you, bolting you onto the end there. As I say, we've covered the Q&A and so forth already. But there have been another couple of questions that have come through, but I think we are unfortunately out of time now. So we'll try and respond to these in writing afterwards. And really all that's left to do is to thank Blaise and Steve as well for taking part and for very useful talk. Particularly to thank Sophie and the Alliance of Business Lawyers for putting together these series of very useful webinars. And from all of us to wish you all a very enjoyable and relaxing festive period, wherever you may be.